Russia's giving the Angle a serious case of deja vu after it's now banning an anti-war candidate from challenging Putin. The Electoral Commission voting unanimously to reject an independent candidate's candidacy just 3 days after her application, citing 100 mistakes on her forms. Because that's what happens in autocracies. That's what happens in dictatorships. In fact, the Electoral Commission in Russia acknowledged that 29 people have filed to run for the Russian presidency, but just one candidate is actually able to register. I wonder who it is. That's right, Putin. Meanwhile, here in the United States and Colorado, in a 4-3 ruling, justices declared Donald J. Trump ineligible for the ballot, citing Section 3 of the 14th Amendment. Now, to be clear, this is an 1868 amendment that was passed in the wake of the Civil War. It's been used only a handful of times to go after Confederates. But bring in Donald J. Trump, and let's delegitimize him from the bench with a novel and bogus legal theory. The ruling's sure to be appealed to the Supreme Court, but is it yet another attempt at election interference? First it was Russian collusion, then 2 impeachments, then the so-called unverified Hunter laptop. Oh, wait, they verified that one. And then you got the 4 indictments, and now disqualification from the ballot. Sensing a pattern? I certainly am. And if you think you could just write in Donald J. Trump, well, think again. The Colorado decision reads, the secretary may not list President Trump's name on the 2024 presidential primary ballot, nor may she count any write-in votes cast for him. That sounds like Russia, not the United States of America. Joining us now is former deputy independent counsel and Fox News contributor Sol Wisenberg. Sol, I mean, you can't even write in the guy's name. What's going on here? And the Supreme Court, what do you think is the trajectory to hopefully overturning this?
Oh, I think the Supreme Court is going to take the case, and I think they're going to reverse the Colorado Supreme Court fairly quickly.
Fairly quickly. So do you think, history serves, you have all of these 5-4 decisions, very narrow. Do you think we could see a 9-0 reversal? Some of those justices move over?
I would certainly like to see that, Kayleigh. They're going to have to look at a lot of things this term that relate to President Trump. I think they're going to take a look at presidential immunity in the context of criminal prosecutions. I think they may take a look at the gag order, and I think it's very important that they try to decide this with as much unanimity as they can. And I really think this will not be a particularly close decision. This section of the 14th Amendment that the Colorado Supreme Court utilized, the majority, is simply not self-executing in my view. And that was the position of the then Chief Justice of the United States, Salmon Chase, in 1869, less than 1 year after the 14th Amendment was ratified. I don't see this so much as an issue of election interference, though it is, as another example of Trump derangement syndrome, this time in the judiciary. And I point out, I say this not as a political supporter of President Trump. I've never politically supported President Trump, but these efforts are very, very disturbing, and they're very anti-democratic.
And, I would love to know your theory on this, but I've heard other legal analysts say, and you know this, I went to law school, textualism, you look at history, you look at precedent, and a lot of folks say there's a reason the president isn't listed in this section. They list all these other office holders, but they don't list the president. And you read that with intention. By design, our founders thought about each and every single word. So do you think this Section 3 of the 14th Amendment even applies to a former president?
That's very much disputed. I think there are good arguments on both sides. It's certainly not clear to me that it does apply to the president. And then if it's not clear, as you know, if the text isn't clear, then you get to go to history and structure and things like that. So some of these questions are close on this issue of what the clause means. But to me, the critical thing, which was discussed in one of the dissents, I believe it was Justice Sam Dorr, who focused on Henry Griffin and the fact that this is not self-executing. What that means is Congress must put teeth into this section of the 14th Amendment. Congress must say, here is how we are going to enforce this disqualification clause. Now, they did that. They passed the criminal law. It's still on the books, 18 U.S.C. 2383. Jack Smith did not indict former President Trump for that. So that's one critical thing. It's not a self-executing portion of the 14th Amendment. And two, you have to provide due process. You have to provide due process to somebody that you're going to take off the ballot. And the process provided here was an absolute joke. President Trump's people didn't have the right to subpoena documents. They didn't have the right to subpoena witnesses. There was not a fair trial in any sense of the word here.
No due process, not self-executing. Fascinating analysis. Sol, thank you.
Hey, Sean Hannity here. Hey, click here to subscribe to Fox News YouTube page and catch our hottest interviews and most compelling analysis. You will not get it anywhere else.